Welcome to the BrightWord Books Podcast. BrightWord is a leading platform for diverse storytelling, where voices from all backgrounds can share their unique narratives and connect with readers from around the world. Follow our regular podcast updates, where we strive to foster a literary community that celebrates creativity, inclusivity, and the transformative power of literature. Hello, and welcome to another episode. Today we have with us Claudette Cupidon, author of Justice Denied, The Price of Ineffective Counsel. Really interesting book today. I think you're going to enjoy our discussion. The book follows the real-life story of Kara and Romeo, who was accused of crimes he did not commit, and goes into themes such as love, courage, and, in the end, faith to overcome the injustice that was suffered. A really intriguing story. Claudette, welcome to the podcast. Thank you so much for joining us today.
Thank you. Hello, everyone.
So I have to ask you, what inspired you to write? Obviously, it's a real story, but what inspired you to write the book?
Well, what inspired me is the amount of egregious act. It's a travesty. It's really like an atrocity. And the more I tried to get assistance from the big guys, like they put all this system in place, thinking that they really like they are like think the places like in when there's a wrongful conviction, and there's a place like where you can go for assistance if you feel that rights were violated, although they also have appeals. That's the ultimate. But the wrongful all these other things, you can also try to get like a quick relief. And I found out at the end that they were just distractions. It's all lies, because I must have written at least 2,000 letters and I never got relief. And there's a particular agency called CJC. It's a commission against, it's where you would report a judge. You feel that like if this person wronged you, like violated your rights. I found out at the end that the head person handling my complaint almost became almost like, I never met him. He sent me letters, but you can read and then put it together like this person is ready to like beat me up or something, and you can feel the anger in their sentences. You can, when you read something as an adult and as somebody who reads, you can get the emotion right there. I'm telling you, I'm not going to docket this file, but yet they did get rid of that judge. I mean, right after my complaint, less than 6 weeks later, this judge retired. And I know it's in the light of my complaint.
Wow.
Yes. These things. And all these things made me wanted to put it in writing. And then fighting, we actually managed to get something called an evidentiary hearing. Okay. So yes. And then once we get that, first of all, I'm going to tell you why I was so appalled about this. It's because we're supposed to trust our lawyer. I think they teach people that. You're supposed to trust your lawyer. You're supposed to respect the judge. You're supposed to respect authority in general. And if we look up to them, we put them on a pedestal, we don't expect that they're the ones who will violate our very rights, because they take a vow to protect us. Because I'm a nurse and I serve people. I take care of patients myself. So my name is Claudette Cupidon, and I'm a nurse and I'm married and I have one son. You see, that's a little background about me. And I love people and I love helping people and I love God, and I want to give God the glory for everything. All glory belongs to God, because who created me and who saves me. And boy, that's the whole thing that happened to me. I'm still in shock. I mean, it's going to be 6 years now, this May 28th coming up. And we're still in shock. We're still in shock.
Wow.
Yes.
Wow. It sounds like just a terrible,
Terrible.
terrible thing that happened.
Atrocity.
And yet it sounds like in the process of researching your book, you discovered that it's not your son is not the only one, that it's happened to others, maybe a lot of others.
Unfortunately, no, because I go to a support group and I spoke with other mothers of wrongly convicted people. And I found out they come to me and say, wow, Claudette, oh, what a pleasure to meet you. Guess what? Me too. My son's lawyer did not investigate anything. Think about it, John. A sexual crime, very serious business. And guess what? It carries a lifetime ramification, a lifetime stigma, a lifetime punishment, really, if you will. Because remember, if you go to prison for a sex crime, you will have to do something called registering as a pervert, really. I mean, really, if you violate people like that, you should register and let people know who you really are. And I agree with them. But guess what? They convicted my son without a rape kit. They convicted my son without any evidence at all. In fact, guess what? There was a medical record, the February 4th record, the day in question. The trial judge of all people decided on day one, she's going to impound. And impounding in legal term means sealing. She impounds the February 4th record. And the February 4th record is the record in question. And it's night and day with the complaint. The complaint says she was given alcohol so they can rape her. Okay. And there's a page, and there's a lab results that says they took her, and there's no better witness than blood tests. A person can make a mistake, can think maybe the eyes were brown or, but the blood test does not discriminate. So there's lab results that says no ethanol. Ethanol is alcohol in the system. And then she also says they did this, they did that. And that's the ultimate lab result that was impounded. And in fact, that deceived the jurors, because the jurors never knew that lab result existed. And that's not the only thing that was in the medical record. She says there was no complaint of sexual assault when she got to the hospital. And it's a very reputable hospital. I don't think I should mention name, but it's a very reputable in Massachusetts. This thing happened in Massachusetts, and the trial occurred on May 16 to May 28. For 2 weeks, they lied to the jurors about the whole thing. So there's medical results, like lab results, that was a lie, in addition to several inconsistent statements that didn't work, that would not have matched. But the jurors were deceived by the judge and also by my son's own lawyer, who was a public defendant. I'm not trying to badmouth public defendant. I'm sure there are some great public defendant, but and I'm sure, because not everybody is in the same basket. There are some, maybe those who who believe in God, who have faith, like who believe in treating people equally. That would do the right thing. And then again, it comes, I'm not discriminating against age, but this lawyer was 84 years old, 85, 84 years old at the time he took on my son's case. And do you know what I learned, John? I learned one thing: whether civil case or civil or criminal cases, investigation is the knee jerk of every case. You have to investigate every case. This lawyer, the 84-year-old lawyer, he went to court, they appointed the case to him the first day. He said, well, I'm going to need money to investigate. And the judge agreed. The judge gave him $1,000 to hire something called a private investigator. He never hired one. My son kept saying, I need to talk to the private investigator because I have points to discuss. My son never met a private investigator. And then there was a trial. And then because the accuser had bipolar and autism, the lawyer must have known that was important because he inquired and requested funds. And guess what? The judge agreed. They gave him $2,000 to hire a bipolar expert. He hired no such person, evidenced by the witness list. On the witness list, I was the only one, and I'm not even impartial. I was the only one called for my son as a witness.
Wow.
And then the lawyer must have known this was important because he inquired about autism expert. The judge gave him $2,000 for an expert. No such person was hired. So there was no private investigator, which is the knee jerk of every case, civil or criminal, because that's how you check facts. That's how you know, like the accusation, whether it's true or not, whether there's any validity to it or not. He didn't hire a private. He pretty much took my son and blindly and trialed this case. And so far, no judge in Massachusetts is willing to just say it. My son was convicted of a sexual crime with no rape kit, and the medical record proved otherwise, and no private investigator, no bipolar expert, no autism expert. He was really railroaded. Let's use it as it is. I mean, we're not offending anyone. Wow. He was railroaded and lynched. That's my take on it.
Wow. Mm-hmm. Wow. And I guess the question is, and maybe the answer, we need to get the book, but what happened at the end of the day? Did he find justice?
Not yet. He's still in there, and he's on appeal right now, and his name has not yet clear, but we have all the evidence. Guess what? This judge made a grave mistake. It looks like after my complaints, she retires. Maybe she was given some kind of deal or something. It's either you retire or you lose, your pension. I don't know. I wasn't there.
Wow.
But something like that happened. And guess what, John? The prosecutor is fired. For a different, I'll tell you, they didn't say it was for us, but I found while reading the transcript, the prosecutor on the last day of trial thanked the judge for leeway. He actually said it, and he used the term leeway. The prosecutor told the judge, not in front of the jurors. This happened right before the jurors came on, like maybe 8:30 or something, before they came upstairs. Because when I was reading it, my son said, Ma, he thanks the judge for leeway. The judge was a woman. The prosecutor said, I want to thank the court. I'd like to thank the court for giving me such a leeway. And indeed, when you block or sealed or impound the exculpatory, they call it, or exonerating evidence, the 5 pages, deceive the jurors. It was like a great plan they executed, but judge lost her career over this case. The prosecutor now is no longer a prosecutor. And I know, guess how they find out? Because I sent that page to the district attorney. And I said, when is it okay in criminal case to be given leeway. And I know that favoritism is the first sign of corruption. They mutilated my son's civil rights when they impounded the exculpatory evidence, because a defendant should have the right to present his evidence. And our own lawyer, who was also 85, may have been demented, for God's sake, I don't know. But this guy he skipped all the step, because I received at the law library a handout about 20 pages. It's from the law. It talks about how to prepare for sexual offenses in Massachusetts. And it looks like it was written in Springfield, Massachusetts. We are in Boston, Massachusetts. But this 20-page handout was written by Springfield, which is Superior Court. So Superior Court, Massachusetts. When you don't hire an investigator, you don't hire any expert, and apparently he never even saw the February 4th record, because there are things called pre-trial conferences. Because if he mentioned it at those pre-trial conferences, there would have never even been a trial. Because if you put the complaint next to the 5 pages, it cancels everything out. Totally. I would like people to read this book, and then I know they can't see all these things, but they can they have to find a way to see. And do you know what, John? There's one thing I want to add before you even ask. They charge my son with 2 STDs. It looks like they underestimated, or they didn't know I was a nurse. They didn't know we could understand lab results. Maybe they underestimated that and treat us like maybe we just, and a lawyer asked me, there was something called this accuser went and had a blood test. A blood test about STDs. March 23rd, I saw the result, because the lawyer gave us everything. It looks like he didn't read it, which he did nothing wrong, because they usually give your lawyer a pile of paper, but they were about 5,000 pages. And guess what, John? I read about 100 pages a day. I made it my business. I read the transcript, which is a 9-day transcript, about 6,000 more pages. So I read about 8,000 pages. I read it 100 pages a day, because I still work. So these people didn't know. My son is an adult. He took a public defender because he didn't have enough to hire a private lawyer. And that's another downfall in this country. I'm not saying all the public defendants are poor, but this guy behaved below. He was so ineffective. Listen, he acted criminally because it was a sexual offense. It wasn't like stealing a lipstick from CVS. It was sexual crime. It was high up there. And he just skipped all the steps by not doing. He skipped all the steps. And then the judge who did after we lost the case, my son went to prison, and then fighting, showing evidence, and then we had something called an evidentiary hearing. When the judge comes, I say, oh, thank God, somebody will have the decency to do the right thing. Yay. This judge says, oh, check, I accept it. When she was presented the 5 pages, the February 4th record were 5 pages. She says, oh, I accept. Check. I'm like, thank God. And guess what? I think she even said, I'll get back to you. It was under advisement. First month, we didn't hear anything. They say, oh, that's a little strange. We can hear from now to. Second month, nothing. 3 months later, she says, oh, denied, because she said that my 2 lawyers were ineffective. My son's lawyers, don't mind me. My son's lawyers were ineffective because they didn't hire an expert to come to the evidentiary hearing. But under the same tongue, she's like double talking, saying, but the trial public defendant just used strategy. It was a strategy that he didn't hire an investigators or expert. That made no sense. That's where the jury was there. That's when the jury was there. And how do you say one lawyer is ineffective for doing the very same thing the other lawyer? That's crazy. And we have all that in writing.
Wow. Claudette, in researching the book, did you come to any conclusions about the cause of wrongful convictions? Is it that sex crimes are treated differently than other crimes? Is it racism? Is it just this country? Do you have any thoughts on what's driving this?
Well, I have thought, and I guess everybody would. I think racism was black and white is a big taboo for even today in 2025 in this country in general, because it was white and black. And not only white and black, the accuser's mother never liked my son. In fact, there was a defamation of character lawsuit my son had out against her because she posted my son on her login on her Facebook. And think about it. My son does not have the same group of friends as her. So my son had no way of knowing what she posted. And her daughter say, my son told my son, here's what my mom posted. She printed it and she brought it to him. And she called my son a nigger and a bastard, and that's how my son took it, went to court and said, you defame me on Facebook. There was such thing going on at the same time. And then she told my son when she did this, if my son doesn't drop that defamation of character, she would add rape, because at first it was just assault. And then after that, they added rape. And that's how this thing happened in 2017. And then 2019, he was the trial. And there you go. And one thing I forgot to tell you, I was reading a lab result, and there was a test about chlamydia and gonorrhea. She went and have it and said, do you think you had that? My son, yeah, he said, Mr. So-and-so gave it to me. And then I got the results. They didn't know they gave it to me, but they gave it to my son. I mean, they gave it filed to my son. The test says, oh, I have reviewed your test results at the urgent care, emergency room. By the way, these two things are negative, So they knew that in March 2017, but yet they still charged my son with these two STDs at the trial in 2019. So these people are criminals. They're no good. And the judge made sure. The judge this time, she says, well, I don't know who had what. How do you convict he wasn't convicted of that because it looks like she saw that was just too out there. So she didn't do that. But my son was convicted of assault. And then it's an accident. There was malicious prosecution as well. And I'd like the people to know that because 2 pages, 5-174 and 5-175 prove based on the accuser's own mother, when she testified to get my son to be convicted, say, oh yeah, there was an accident, by the way, with this young lady and my son in his car. And she sued my son. She sued us and got $32,000, well deserved, because she was injured. So yes, well deserved. We have a paper on the transcript where the prosecutor said, "Oh, I'm worried to charge him because she got compensated for the accident." So it looks like the prosecutor was a liar. And there was malicious prosecution, and we're going to eventually get that into appellate court. So we're going to get that. And By the way, he's fired, I told you, by the district attorney. So now he can never be a prosecutor anywhere in Massachusetts. He's doing some other law now. He can't be a prosecutor. And then they say it was related to some other unrelated corruption. But trust me, after 8 days, I reported the leeway statement. I followed these people like a hawk, and he's fired. Less than a week.
Wow.
So I know it wasn't other corruption. It was this case, because it looks like he should have never thanked the judge out loud on transcript in writing about leeway. Because how do you give leeway? And then do you know the worst thing this judge did? I had to tell you, even if you didn't ask me. The trial judge, impounded the February 4th record, all the exculpatory evidence, 5 pages, told the defense lawyer for my son, these are private records. You have no business talking about it in front of the jurors. Okay. Guess what? This judge allowed the prosecutor to use the February 3rd record as exhibit evidence. She did something illegal.
But
we got her there.
But not the one that you put together.
That's where we got her. And guess what? We got her. Is that bias? That's even criminal. That becomes criminal, because she mutilated as a whole, the 3 of them mutilated my son's civil right. If you impound a record, it should be impounded for both sides. You cannot impound a record that has exculpatory lab results for one side and then allow the prosecution to use the very same impounded record as exhibit evidence against my son. And then keep in mind that the jurors had no knowledge of these things. So of course they're going to convict my son. But there was no rape kit.
Wow.
It's she says, he says.
Wow.
And guess what?
Wow.
This judge said, where it says defamation, where my son was called a nigger and a bastard, the judge said, in fact, that's not defamation. Yeah, the mother had the right to say that. And then when I wrote to the supervisor judge of the Superior Court, I said, if it was her own children or herself that they called that, would it be okay too that it wouldn't be defamation? Is it defamation for my son because he's Black and it's not for them? It wouldn't be for her or her children? So that all these things, listen, I've never seen anything. We have so much evidence. I don't understand why the state never called us to talk to us.
Wow.
And we didn't, listen, we didn't make this up. Every medical record page has the court seal on them. So nobody went outside to get anything. And I did send the evidence to them. The court seal, every page, they never skip one. And when I send them everything, I said it has the Superior Court sealed. And one more thing you'll be interested to know. In my research, I found out that Massachusetts is number 2 in the nation to wrongly convict on rape. We're leading. Maybe I didn't see who the first state was, but Massachusetts is number 2 in the nation to wrongly convict. So that's why I'm doing this, and that's why I wrote the book. And this article is written by a group of lawyers. And do you know what? I want to tell people, to the viewers and the people listening, another case that as bad as my son's case right now is the Karen Reed case, if you're following it at all. At least listen to a little blip of it. Listen, they're so corrupt, it's not funny. The Karen Reed case, where the prosecutor, the state police, the investigator is fired because of corruption. All eyes are on them, so they had to do it. Because they say it's hard to fire.
Wow.
Yeah, the state police, Mr. Proctor, is fired in the wake of him sending text to everybody, his friends, whatever, and then calling Karen Reed a whack job and everything. If you listen to that podcast, so you'll want to throw up, really. Sorry.
Well, Claudette, our time unfortunately is coming to a
That's
close. But before I let you go, I just wanted to confirm that your book is available on Amazon
And Barnes and Nobles.
and Barnes and Noble. Terrific. It sounds like a really intriguing
True
story. And
story. We suffered.
I
I
know
dropped 30 pounds. My son dropped, it was an athlete drop. We lose because we had sleepless night in the beginning. And even today, on and
I
off.
don't blame you. I don't blame you. And I know our viewers and listeners would join me in wishing you the best of luck as both you and your son pursue
Thank
justice.
you.
Thank you. We've been talking with Claudette Cupidon, author of Justice Denied, The Price of Ineffective Counsel. I'm sure you'll want to pick up a copy, and we thank you again, Claudette, for being with us today. You've been listening to the BrightWord Books Podcast, home of the literary community that celebrates creativity, inclusivity, and the transformative power of literature. Don't forget to subscribe so you'll never miss future episodes. Until next time, stay informed and stay engaged.